This conference will now be recorded.
For
This
joining us
conference
from
will now
Chicago.
be recorded.
So a couple of housekeeping announcements. First of all, thank you all for joining the call, and we will be delighted to answer your questions as we go along. You must send your questions via the chat box. You see the little chat bubble on the right-hand corner of your screen. You may direct the questions to Purvi Chothani. There are two of us who have joined under my ID. We both are the organizers. You can send it to me. And if you want the whole audience to see it, you may post the questions to everybody, but you don't have to. We are going to keep everybody's mics and videos off except the speaker. So you will be able to see Jane when she's speaking and Zeenath when she's speaking, and I will be moderating this session. So you will, your videos will be switched off because we are going to otherwise have bandwidth issues, and it's also very distracting for the speakers. So please forgive us for that, and all your questions will be answered as they are received in the chat. We will not be able to give an open mic, but we want to address your questions. So please keep them coming. So today we are going to have um, two main speakers with me moderating. I'm Purvi Chothani, the managing partner of LawQuest, and we've got two senior attorneys. We've got Jane Skelly Carroll, who is based out of Chicago. She's got significant corporate experience and private practice experience, and she's been associated with our firm for several years now. We've also got Zeenath Fofalia, who's a U.S. attorney who works out of the Mumbai office. She also has more than 15 years of experience in U.S. immigration and has been working on hundreds and hundreds of H1-B cases, as has been Jane in her career. So they both come to you with a robust experience and up-to-date knowledge of what is happening in the H1B field, which is very important considering the changing times that we are in. Changes in the terms of the work environment, changes in the terms of the H1B process, and many more changes that are happening are pertinent to that. This COVID-19 situation has created a lot of changes for all of us in the way we work. All of us, I'm assuming, are working from home. We've been working from home for almost a month now, as has some of our clients, as they indicated on the call a little while ago. The situation is really tough, but I think that with technology, we're all able to manage somehow. The US CIS has not stopped its operations, though Vermont Service Center did announce recently that they're closed for decontamination because they think that they had a contamination exposure. So the Vermont Service Center till April 15th is not operational, but otherwise the USCIS has announced that it is operational, and all non-contact services will continue. So no biometrics, no immigration interviews, etc. But petition processing continues, which is good. We also know that with the H1B process having changed this time, there may be questions from the audience about how that whole thing is going to pan out. So we will talk a bit briefly at the end on the H1B selection process, what has happened, how it's going to pan out as per the current regulations, and what, if any, penalties, or could you face any penalties if you don't file all selected cases. So we will talk about that later in the discussion. Our main focus on today's presentation is, I request you all to please mute it because we all have children, pets, and many things happening at home. We'd love to participate in your lives, but not today. We understand that most of the concerns are that employers want to see how they can protect their workforce and how they can mitigate their losses, and yet take steps to do this without triggering Department of Labor inquiries, audits, or penalties. And that's what we are going to focus on today. We're going to start with a question for Zeenath Fofalia. Rupali, if you can activate her camera. Hi, Zeenath.
Hi, Purvi.
So So Zeenat, we want to know, we want to tell the audience, does an employer have to continue to pay the salary that they indicated in their LCA when they filed their petition?
Thank you for the question, Purvi. A good evening to everyone who's joined in from India, and a very good morning to some of you I see who are joining in from the United States. My name is Zinat Fafalia, and I'm a senior attorney with LawQuest. We really do hope that some of the topics that we're covering in today's webinar will help you navigate through some tough and unique situations and issues that you're probably facing or may have to face in the current crisis situation. So to address the question, does an employer need to continue to pay the LCA wages? As some of you may know, by filing an LCA labor condition application, the employer attests to the Department of Labor that it will pay its H-1B worker the required wage, which is the higher of the actual wages paid to similarly situated US employees and the prevailing wage within that occupation for that particular geographic location. Now, the employer's obligation to pay the LCA wage pretty much continues through the entire time that the worker is in H-1B status. So in the current situation where a large number of employees are having to work from home, or in situations where they're rendered unproductive due to unavailability of work, even in such situations, the employer's obligation to pay the LCA wages continues unless there is a bona fide termination of employment. Now, the employer may be able to reduce wages, and I will get to that in a little bit later in the discussion. Failure on the part of on the employer to pay the required LCA wages could expose the employer to fines, back wages, and potentially debarment from H-1B program, from immigration programs.
Okay, Zeenat, we are having trouble with your internet. Is this the best connection you can have today?
Yes. Are you not able to hear me clearly? Hello?
Address that as we go along. The next question is for Jane. Carol. Jane, are there any government announcements that offer relief to companies as they continue to pay salaries, or to encourage them to pay salaries, Jane?
Good morning, good evening. Yes, I mean, the payment of salaries during this financial crisis has been a primary concern of employers. So as part of the relief package, the stimulus package that was approved by Congress a couple of weeks ago, there was a provision called the Paycheck Protection Program. And this is going to be a great boon to employers, smaller employers with 500 employees or fewer. They can get low interest government loans up to a total of $10 million. And the amount of the loan will be determined by 2.5 times the monthly payroll of the company. And capped, as I said, at 10 million. And then individual employees can receive a salary up to $100,000. So any employee whose salary exceeds $100,000 would have to be covered by the employer, but the protection program would guarantee up to that point. So this is very, very helpful for employers, but they have to get in there and they have to apply for it. Hey, could you hear that?
I'm not sure. I mean, I couldn't hear you, but I'm not sure. Rupali, could you hear Jane?
Yes, I could.
Okay. I am hoping that the audience heard you, but I'll just give them the one-line answer that for small businesses, the US government has announced the Payment Protection Program, where employers with less than 500 employees can get low interest loans, which could be waived off at the end of 8 weeks, subject to certain conditions. Our next question is for Zeenat. Zeenat, if companies are going to furlough their US workers, can they furlough H1B workers as well?
Right. So under the immigration regulations, employers cannot furlough H-1B workers or place them on unpaid leave if the employer is unable to pay wages during that time, or if there is no work available for the employee. In the current situation, we're seeing that a large number of employees are rendered unproductive due to the lack or shortage of work. Also, a large number of IT companies typically deploy their H-1B workers to end client work sites. Now, if these end client work sites have shut down, a lot of times employees are unable to perform work out of their homes due to the nature of work and for security reasons and so on. So essentially, the employee is rendered unproductive. Remember that the employer's obligation to pay the LCA wages continues at all time, at pretty much the whole time that the employee is in valid H-1B status and is available and willing to work, regardless of the employer's inability to pay or unavailability of work. Employers who bench their H-1B workers without pay run the risk of being subject to fines, back wages, and potentially debarment from immigration programs. Employers do have the option to reduce the H-1B workers' wages, but any such reduction of wages would be considered as material, and therefore a new LCA reflecting the change in wages needs to be filed, accompanied by an amendment petition. Also, keep in mind that an H-1B worker's salary cannot be reduced below the minimum prevailing wage applicable to that particular geographic location. Alternatively, the employer has an option to terminate the employee's employment, but they need to pay for the employee's return to his country upon termination.
Okay. Jane, what about if the employee himself is afflicted with COVID-19 or any of his family members are afflicted with COVID-19? What relief, if at all, could they hope to have in terms of sick leave of absence under state or under federal law? I mean, if you can give us some guidance on that, it would be great.
Right. Yeah, Purvi, if an employee tests positive or has to be quarantined because they've been exposed, the odds are they cannot work. And that the question there is that voluntary? They have, said I've been exposed, can't work, or realistically, the employer would not want that individual coming into work. So the chances are it really would not be involuntary leave. So in that case, if it's involuntary leave, the employer would still be required to pay the employee during that period. The employer should bear in mind, though, that there should be some relief available under the Families First Coronavirus Response Act for paid sick leave. And another thing that employers must be aware of in the United States is that one of the greatest concerns that employees have is their own health insurance, because that tends to be provided, as you probably know, we don't have any sort of government provided health care in the United States. Most people receive their insurance, health insurance, through their employers. And so if employment is terminated, then they often don't have health care. So they're kind of in a conundrum, and that's why the Family Coronavirus Response Act would be a great help to employees who must take leave during this period.
So do they get 2 weeks of leave? Is there something like that?
Yes, I believe they get 2 weeks of leave.
Yeah. Okay. Zeenat, you mentioned that we cannot reduce their salaries unilaterally, but suppose the employer reduces their work hours, what should they be taking care of?
Right. Like I said earlier, Purvi, and I reiterate that employers are required to pay the LCA wages at all times that the worker maintains valid H-1B status. Now, in a situation where the employer reduces the work hours or from full-time to, let's say, part-time employment, and proportionately reduces the wages as well, then the safest course of action here would be to file a new LCA reflecting the changes and an amendment petition. Employers need to keep in mind that the H-1B worker's salary cannot be reduced below the minimum prevailing wage for that particular geographic location, nor below the average wages paid to other US employees. Now, in the current situation, we're seeing that a lot of employers are wondering whether the grant of stock options would qualify as wages. Typically, any guarantee of stock options will not be considered as wages by the Department of Labor, and therefore any such promise or assurance to supplement or make up for reduced wages by way of stock options would potentially trigger employer liabilities. That said, a guaranteed bonus, so a bonus that is not conditional or is non-contingent, can, however, meet the wage requirement if it is paid as salary at a later time and appropriately reported. But again, there is uncertainty as to how the Department of Labor may view this arrangement should there be an investigation. But there is also some speculation that the Department of Labor may just take a liberal view given the current unprecedented situation that we're all in.
Okay, so suppose it was an H-1B dependent who was relying on the $60,000 salary, and the employee is being paid about $75,000 per year. Zeenat, could he reduce the wages at all? The employer, could he reduce their work hours at all?
Right, so he could reduce the work hours per week, but he cannot, if it's an H-1B dependent employer, then the employer cannot reduce the salary below 60,000 US dollars a year.
Okay, so just give me a second, please. I'm having trouble with my web camera. Got it. Sorry. So, Jane, one of the things that Zeenat mentioned was that to terminate LCA obligations, we need to terminate the employee. Could you tell us a bit more about that?
Yes. Well, under the H-1B regulations, Purvi, if an employer terminates an H-1B employer before their authorized period of stay, say before the petition is completed or before their term of employment is completed, then the employer is obligated to pay the return transportation costs of the employee back to his or her home country. which can be kind of a problem right now because, as you know, there are flights going into India, for example, so, some employees might not be able to even return to their home country. One thing that the employee should consider is changing status or first of all, there is a grace period upon the termination of employment of 60 days. So during that 60-day period, it's a time when the employee can kind of gather his wits and figure out next steps and either leave the country or find another employer or pack his bags, whatever action that employee might need to take. But in that period, the employee could also file for a change of status to another type of non-immigrant status. So for example, an F1 student or a B1, B2 visitor, but any petition to change non-immigrant status must be filed within that 60-day grace period. If it's filed beyond that, you're out of status, and out of luck for doing a change of status. But a little caveat too, in something like applying for a change to F1 student status, you'd actually have to be a student. You'd actually have to apply to university. You'd have to have the I-20 document and other documentations issued to be eligible to be a student. And you'd actually have to be a full-time student. So it's not just a matter of switching to student status just to be able to stay in the United States. So that's just a little caveat.
Right. So is there any reporting requirement to the USCIS, Jane, to terminate your obligations?
Yes. So the employer is under an obligation to inform the USCIS of the termination in writing and to withdraw the LCA that was filed with the Department of Labor. Both those actions must be taken.
Right, sorry. But Indian IT companies file LCAs for multiple employees. In that situation, they cannot withdraw the LCA. So would that termination notice to USCIS suffice then?
It would suffice, yes. If there are multiple employees on the LCA, yes. You can't jeopardize all the employees by withdrawing the LCA. No, I'm glad you made that point. Yes.
Correct. I just wanted to share one of our clients' situation over here. We have a client who's got few H1-B workers who've come to India to get their visas renewed or for some family purposes, and they're unable to travel back. So they continue to do work for the US entity from India. Now, the question was, do they have to pay them the US salary or do they have to pay them the Indian salary? So the advice we gave them was, if you want to stop your H1B obligations and the people are in India, the best thing to do is to send the termination notice to the USCIS and have them continue working in India. Once this situation blows over, then they can file a petition for that, which would be a cap exempt petition, and get them back to the United States to work. The other risk that companies face when they have their workers working out of India but on the US payroll is that they could trigger tax liabilities for their US company in India, which is not related to immigration, but it's a huge risk that companies take if they continue to retain them on their US payroll. So that is the unique situation we saw, and I thought I'd share that with the audience. Zeenat, we've got strict LCA posting requirements under the H1B program, and there are two situations here. One situation is where the employees are working from home. Then how do you comply with the LCA posting notice? And then we have a second situation where employees will now begin filing their H1B cap petitions, and how do they post their notices? They're not going to office, so how do they post their notices? Could you please help us with both these aspects of LCA postings?
Sure. So in the current COVID-19 pandemic, we're seeing that a large number of employees are having to work from home to comply with stay-at-home orders.
Sorry to interrupt. Sorry, could you put on your camera, please?
Sure.
Yeah, sorry, could you start over also?
Yeah. So in response to the COVID-19 pandemic, a large number of employees are having to work from home to comply with stay-at-home orders issued by various states. Employers need to ensure that they continue to maintain their LCA obligations in a worksite change scenario. So let's say if an employee is working out of home and his home office location is within a metropolitan statistical area, MSA, of his primary permanent worksite, then in such event, there is no need of filing a new LCA and an amendment petition. The Department of Labor has clarified as to what constitutes normal commuting distance. So there is really no rigid measure of a distance for normal commuting distance. So if the H1-B worker normally commutes from his residence to his work site listed on the approved LCA, it is within normal commuting distance. And any work site within the MSA of his primary work site would be considered within normal commuting distance, even if it's across state lines. You know, this is just a provision provided by the DOL to provide employers with the flexibility of deploying their workers to in response to client requirements and opportunities in new locations. So if an H1B worker works out of his home, which is within the same MSA as his permanent primary work site, no LCA is needed. All that the employer needs to do is put up the LCA posting notice at the employee's home location. Again, the DOL has provided some relief in this regard. So the LCA posting notice will be considered timely if it is posted as soon as practical and no later than 30 calendar days after the employee begins work at the new location. Now, what happens if the employee's home location is outside the MSA of his primary work location? In such a scenario, the employer can avail of what is known as a short-term placement. So the short-term placement provisions allow an employer to place H1B workers at a work site not listed on the approved LCA for a period of up to 30 work days in a one-year period, which in effect amounts to about 6 weeks a year. And this can be extended to another 30 days, but no more than 60 days in a given year, provided that the employee maintains ties to his permanent work site, spends a substantial amount of time there in a year, and the other terms and conditions of his employment remain the same. I also do want to add here that the 30 and 60-day periods are calculated in the aggregate in a calendar year. So if a certain number of days have been utilized under this option, the employer may not be able to use the entire 30 or 60-day period for COVID-19 purposes.
Thank you. Jane, I'm going to ask you to please help here. Could you help us talk about a bit about the electronic LCA posting? Would you be able to help us with that, please? Because in the COVID-19, when we're filing our CAP petitions, we still have to file the LCA notices. So how does one do it?
Well, are you talking about the two kind of anomalous situations, the employee working from home, you know, whether...
No, I'm talking about, you know, we are filing the petitions for an October 1 start date, and
Right.
that is a long way away. Hopefully COVID will be gone by then. But we need to post the LCAs, the notices before we file them, before we submit them to the Department of Labor. So I believe you can do an intranet posting, you can do an electronic posting. I just wanted you to elaborate on that, please, if you can.
You can, and that could be a viable option, particularly during this period. So if a company has some sort of internal intranet system, which most do, the LCA can be posted internally on the intranet. You just have to make sure that the notice of that posting is given to the appropriate group within the organization. So those who, similarly situated workers in a similar occupational category. So they just have to be directed to the spot where they could, there's probably a link then to the posting. So yes, that would work. And there are certain hosting sites that employers can utilize for the purposes of LCA posting. But as a practical matter, the intranet is probably a better choice, and better able to document. It's just in a situation like this, you have to be able to show, in the public access file that this posting was actually made, and with the link to where it was posted, and be sure to print it out so that it's visible to see should there be an audit.
Sure. So one of our clients, we worked with them and we sort of worked out a situation, and I believe that that is compliant, and I'm going to share it with the group, is that they post many of their employees at the third client worksite, and the third client worksite does not have an intranet which their employees can access. So what this company has done is they have posted their LCAs on their own intranet and internet on their website, the public facing website, and then they have sent an email to the affected workers at the end client directing them to the LCA posting notice. So I believe that that is compliant, Jane. Would you agree?
Yes, yes. I think the effort to inform the employees and to show the steps taken would certainly mitigate any sort of
Right.
sort of variance with the actual compliance with the LCA posting. You tried, made your best efforts, and this is what we did.
Yeah, because the standard for the LCA posting is the best effort standard. It's not it's not I mean, you've got to show that you did put in your best effort to post it and give notice to the affected workers.
Exactly.
So I'm glad you agree with that strategy. Thank you.
Yeah.
Now we come, Jane, you spoke a bit about changing your status if you want to remain in America. But after their employment has been terminated, you mentioned they can stay there for 60 days. How about if they have a new employer within that period? Can they start working immediately, or how will that work?
Well, if the new employee, if within that 60 days, if the employee has secured new employment, new H-1B employment with a new employer, that employee can commence employment upon the timely filing of an H-1 exchange of employer to the new employer, and that employer receiving the receipt notice of the filing of the H-1. So yeah, under those circumstances, yes, the person could then work.
Right. Okay, we've started getting audience questions, so I'm going to read through those now. Can a beneficiary that has been denied with an expired H1B work if we file an H1B transfer? This is a bit beyond that, our discussion today, but Jane, if you can answer that, it would be great. Otherwise, I'll take it offline. I'm going to repeat the question. Can a beneficiary that has been denied with an expired H1B work if we file an H1B transfer? That is the new employer. The new employer files a petition for him.
Right. But if the prior petitioner has been denied and that person is not maintaining status, is out of status, so to speak, then the change of employer part of the application would not be approved. I mean, the H-1 employment might be approved, but not the extension of stay in the United States. So the issue there would be the petition would have to be approved before the person can commence work, and probably, unfortunately, be subject to consular processing. Go back to And probably, go back to the home country, go to the consulate, obtain the visa, and re-enter.
So they could, so the beneficiary could not benefit from the H1B portability because his status
No.
has terminated.
No,
Right. Got it.
no, could not benefit from portability.
Right. So now we have another question which says, do you believe that the due date for the online registration, the petition selected in the online registration, do you believe that that date will be extended beyond June 30th? Zeenat, would you be able to take that for me, please? Okay, I'm going to go ahead and answer that question. The answer is that at the moment, the USCIS has not extended the date beyond June 30th. However, when they did announce the new online registration process, they had said that the cases have to be filed within a 90-day period. However, it may be changed, that date may be changed at the discretion of the USCIS. So we are hoping they'll use the discretionary power and extend the date. But as of today, all cases have to be filed before June 30th, on or before June 30th. We did have a question which said, what is the grace period an employee has if he is out of a job? That question has been answered. It is 60 days. We have another question here which says, if an associate's case is stuck in 221G, and now that visa processing has been temporarily suspended, how long can he continue to get his US salary? I think this also we addressed. I mentioned that there are people stuck like this. The best thing is to terminate their employment or continue paying US salary, because failure to do so will be considered as benching. And not only if Department of Labor doesn't come after you, the employee then can go back to America and file a whistleblowing complaint against you that you were actually benched in India. Though you were working US, the employee is working US hours, working on the US project, you're not paying him US salaries, etc. So the best thing is terminate him and continue him on Indian payroll, or just don't have him work at all. Okay, I think even the next question about the notice posting has been addressed, but I have a question over here which says, Jane, may I have you answer this? What are the penalties for non-compliance with meeting the H1B salary obligations? What could companies face potentially?
Well, there are always risks of monetary penalties, civil penalties. Back wages is a big one. You'd have to go back and pay whatever wages, and probably penalties as well for the period of the violation. And a big risk is debarment from participating in not only the H1B program, but also immigrant programs as well. So an employer can be barred from, non-immigrant and the permanent residence program, terms and whatever. So yeah, I mean, it's a risk to be careful of. Yeah.
That could be used. We have a question from the audience, but I need you to resubmit the question. The question is, what about if a H1B CAP filing location does not have an LCA pointer? I'm not sure I understand what an LCA pointer is. So whoever posted that question, if you can repost it, we'll try and answer it. In the meantime, Zeenat, I have a question for you. Can terminated foreign national workers seek unemployment benefits? Because just now, lots and lots of American workers who are losing their job are seeking unemployment benefits under their social security system. So can H1B and L workers seek that benefit?
Sure, Purvi. And apologies, I'm having some technical difficulty with my camera, so it's not working at the moment. But so unemployment benefits are typically governed
Zeenat, we
by.
can't hear you.
Yeah. Is it better now?
Yes, that's better. Thank you.
Okay, great. So unemployment benefits are typically governed by various states. So one needs to closely look at the specific states' rules and regulations to get guidance. Now, that said, a foreign national worker is employed pursuant to a visa status, and such worker cannot claim unemployment benefits because he or she will not be considered to be available for work, since his or her employment authorization was tied to a specific status. So unlike U.S. workers who are laid off or terminated, could look for work elsewhere, an H1-B worker upon termination would lose his work authorization status and would technically not be considered to be available for work, and thus would not be eligible to apply for unemployment benefits.
Right. And in addition to that, I believe that there are risks that if they did get that benefit, they could also face further problems down the road with immigration, because they might be considered public charge risks. But there's not enough clarity on that. But that is another thing employees should be concerned about. Jane, I have a question for you. You mentioned that they can file the change of status application. So let's say an individual decides that, I mean, not decides, he just can't travel to his home country. When should he file his change of status application? At which point? And what will failure to do that mean for him?
Well, any change of status application should be filed within the grace period, that 60-day grace period allowed after termination of employment. If such application is not filed, the person runs the risk of accruing what's called unlawful presence, which is something that I think it's been out there a long time, this law, since 1996, but often has not really impacted employment-based immigrants so much. But I think we're going to be seeing a lot more unlawful presence situations. So unlawful presence does not just mean that you've violated your status, like unauthorized employment. It means that the individual has stayed in the United States, remained beyond the authorized period of stay, of admission. So that could be that the person overstayed their I-94 admission. It could be that they stayed beyond the approval of the underlying petition that's expired. It could be a cessation of employment situation, termination, and it's gone beyond the 60 days. So when that date certain has occurred, that is the date that the individual begins to accrue unlawful presence. And unlawful presence, if you've accrued 6 months or 180 days or more, or 180 days of unlawful presence, that means that you are barred from any non-immigrant visa or immigrant visa for 3 years. If that unlawful presence continues and amounts to 12 months or more, then the bar is 10 years. Now, it's harsh. It's very harsh. And it means that, yes, in theory, you could get an approved petition, but you'd have to depart the United States to obtain the visa and come in. And when you depart the United States, that's when the bar comes up. You go to the US consulate, they'll see that you're subject to the bar, and they'll say, sorry, you might have an approved petition, but we can't give you the visa. And it's very difficult to get a waiver, and there you are stuck, for 3 or 10 years. Now, there's discussion of, will this be waived, or will there be discretion, whatever. I think we have to be really careful on this one, and we have to watch it, because the 3 and 10 year bars are law. That's statute. That's not discretionary. So how this is going to be handled in the coming months, I really do think we need to keep our eyes on it. But for now, I think it's people better be cautious and understand that the 3 and 10 year bars could be a barrier.
So we are hoping that the USCIS will extend people's statuses automatically, like that has been done in the United Kingdom. In India, also foreign national status has been extended, provided you do some simple online filings. So many countries have taken proactive steps to protect their foreign workers, but not yet from the United States completely. But we do have some relief from the USCIS. For instance, they are accepting copies of forms that have been signed. Scanned copies of forms can be printed and sent to the USCIS. They are not insisting on wet signatures for now, which is a welcome change because it's impossible to coordinate wet signatures when courier services are not working, or there are FedEx and UPS have stopped their guaranteed delivery services, etc. So they have made that relaxation. The other relaxation that they have made is that they're going to use old biometrics. So this applies especially to the H4 and the EAD card applicants. Their prior biometrics will be used for their new extension applications. However, applicants who are first-time applicants are out of luck because they don't have the biometrics on file. They don't have the relevant, I mean, the biometrics with the relevant agency on file. So they will not benefit from this relaxation. The third relaxation that has come is on the I-9 compliance. For the I-9 compliance, within 3 days of the employee joining, you've got to make sure that you have physically examined the original document authorizing that person to work in the United States. The government has relaxed that and given a 30-day window in which you can do a um, remote verification of the documents. But soon after this is lifted, you've got to make sure that you do the physical examination of the original document and appropriately annotate the form I-9 about why the delay, and ensure that you mention that the delay was due to COVID-19 and justify by enumerating the days and how quickly you took steps when you could take those steps. So these are the 3-4 important relaxations that the government has announced. Now we will talk a bit about um, we will talk just briefly about the H1-B lottery and how that is um, panning out in terms of practicalities. So, 275,000 applications were submitted online, of which, of course, the 85,000 were selected, and all the employers have got notices of their selected employees. There were 100 cases that were denied, and apparently they were wrongly denied. So the American Immigration Lawyers Association is taking that up with the USCIS to see how the glitch happened, and they are going to hopefully sort it out. But in the meantime, anecdotally, we've heard from several companies and several of our fellow lawyers that the companies are not ready, or they do not anticipate needing all the employees that were selected in the online process. Now, this is really something unusual. I mean, usually you get 100 selected and you wish you had 150 selected. But this time the situation is almost turned on its head, where employers are very worried that they may not be able to find work, or they may not have those projects that they had anticipated when they filed the online registration. And they're thinking of filing for fewer beneficiaries. um my first reaction to the clients is, don't do that. You can face all those penalties. You can face the penalty from any of those H1B program violations. Is similar penalties. The government has not enumerated them, but they have said that under federal law they will be considered to be misrepresentation of fraud if they don't file for all their cases. So in a situation where a company has got 100 selected and you don't file 3 or 4, I think you would be okay, because then your number is not so off. But if you got 100 selected and you think that you don't have work for 40 people, you'll be in trouble. So it's better to file for all of them. It's going to be an expense, but I would suggest that till the government makes a decision or grant some relief over here, you should be preparing to file all your cases and then withdraw them at a later stage if you can't prove that you have work. But otherwise, you should be preparing to file them. Um, the what I also believe that could happen is that many employers are thinking of not filing all the petitions that have been selected. So if that's going to be like a large volume of cases not filed, I don't think the Department of Labor is going to go after all the companies. It just would not be practical. But we've got to wait and watch. till they make an announcement. We have one more question from the audience. Um, this is applicable due to COVID fallout on H1B cap filing. If there's an H1B cap client location, let's say is a new one, and we have not done a posting there, and hence there is no LCA pointer available for the said location, since people are working from home now and the client offices may not even be open, how can we address this lack of LCA posting? So the question, I mean, I'm just going to briefly summarize it. I believe the question is asking, the questioner is asking, how do you post an LCA at an empty office? Technically speaking, it makes no sense. But if you've got to comply with the letter of the law, then if somebody can go to the office and post it, they should post it. But if it's at the third party side, we address that. Excuse me. At the third party side, we address that. You post it on your internet or on your website or intranet, and send an email to the affected workers at the end client site. That's going to be a bit of a challenge, because how do you do it? How do you identify the affected workers? How do you get their email addresses? You can even post letters to them. Hard copy letters also is effective posting. But that's a challenge. You'll have to work with your end client to work out a solution on that. But yes, you do need to do that. We have another question over here which says that the status on the online selection process is submitted. What does that mean? Zeenat, could you help us address that if your mic is working? Okay. Um, okay, I'm going to take that. I don't know what happened. Are you ready, Zeenat?
Yes. Can you repeat the question, please?
Yes, if on the online registration portal a case appears as submitted, what does that mean?
So I believe that what that indicates is that the registration was properly filled out and has been entered, taken on file by the USCIS, but that does not mean that the registration has been selected. Now, I believe that the USCIS is keeping certain registrations, properly submitted registrations in reserve in the event that it needs to tap into more petitions for adjudication.
Right. So I think I'm just going to add a bit over there. So the cases that appear as submitted will remain in submitted status until the beginning of the fiscal year, that is October 1st. And the USCIS has indicated that all properly filed cases that were not selected and have not been denied will remain in submitted status until October 1st. So if I were you, and I had many of these submitted cases, I would still watch, because some of them, as employers don't file their online selections, if they don't file them, more numbers will become available and you may get selected. The USCIS has not announced how they're going to select them. Are they going to do another random selection? Or we have no idea of how they're going to do it, because I don't think even they anticipated so many cases not being filed. So we've just got to wait and watch. But till it is in submitted status, you still have some hope. Okay, now. There's a question asking for clarity on the posting notice about after 60 days. So yes, if the worker is working at a location other than the primary work location, but yet continues to maintain the workstation and the permanent place of work at the primary location, he can be working from the new location for up to 60 working days. It is important to post the LCA notice even then. And that for that, the Department of Labor has given you a 30-day window, which is separate from the 30-day remote work, the 60-day remote work. There's still another relief that the Department of Labor has given, that you can post it within 30 days. So yes, you should post the LCA provided it is in the same MSA. If it is outside the MSA or if it is outside the normal commuting distance, then you need to file a new LCA, post it, and file a new petition. Okay. I think we are at the end of our questions. Unless anyone has one or two last ones, we still have 3-4 minutes to take them. Otherwise, we will wrap up. Thank you so much, Jane, for joining us from Chicago. We are very sorry to make you start your day so early, but it was a real pleasure having you on.
Well, thank
Do
you
you
for
want to
having me.
make any closing remarks, Jane?
Sorry?
Did you want to make any closing remarks?
No, it's been a pleasure. This has been fun and unusual way to, but we have to adapt and be flexible under our current working conditions, right? But anyway, thank you for having me.
Okay. Sorry, but we've suddenly got a couple of questions. If an employer has less than 500 employees and there is a need to reduce the count due to less projects, how will the stimulus package benefit? So the stimulus package is going to be given to small employers, and it will be considered a loan at a low interest. However, at the end of 8 weeks, if you prove that you've not terminated employees or reduced their work hours, they may waive your loan. So can you get the loan even if you are going to terminate some employees? Yes, you can. Will you get the loan waiver? Probably not, because you're going to terminate some employees. That was one question in 3 parts which I've addressed. Okay, Jane, thank you so much. And thank you, Zeenat. It's been a pleasure. We've been in the same room and presented many times, but across oceans this time. Thank you.
Okay, thank you.
Thank you so much.
Thank you,
Thank you,
Purvi.
Zeenat.
All right.
Thanks.
Bye.
Thank you.
Thanks, everyone, for joining.
Jane.
It was a pleasure. We appreciate your time and hope you found it beneficial. Thank you. Bye-bye.
Bye. Thank you.